Good afternoon, everyone. Welcome to our October 2nd webinar on parking violations and towing. October, it's already October, you guys. Ugh, years just flying by. My name is Alina Gilbert. I will be presenting this webinar today. And before we get to all the goodies, I'll let you take a quick laugh while I go through some housekeeping items. So first of all, thank you for joining us. And second of all, as I've already said, I'm Alina Gilbert. I'll be presenting. On your screen, you should be seeing, most of your screen should have the PowerPoint with the Mustang getting towed. On your left side, you are going to see a little picture of the presenter. That's me. Hello. And then to your right, there's going to be an icon called chat. So you would go in there and type all your questions as we go through the webinar. I am going to save them for the very end. I think we're going to have plenty of time to go through all the questions and answer them. So just type them in and know that I will get to them at the end of the presentation. If you are having any audio problems or video problems, you should see a little button at the bottom that says audio or video problems. Click on that. It takes you through a few steps and hopefully resolves the issue for you. We are going to be issuing one CMCA credit today. Sorry, I just got a funny comment. If you haul off a frog, is that called getting towed? T-O-A-D. Ha, I love it. Thank you. That was great. Anyway, one CMCA credit is going to get emailed to you. And just as a reminder, these sheets that you get, the emails with the actual credit certificate on there, they disappear after 30 days. So you need to actually save the certificate to your computer to make sure it does not go away. Please, please do that. Otherwise, it's going to be gone. And then you're going to have to call us and see if we can generate another one for you. Just so you know, the credits are not transferable, not that I assume any of you want to transfer them. Anyway, we are recording this presentation, so if you love it or you really hate it and you want to tell people to go watch it, either because you think it's good or because it's bad and you hate them and you want them to see a bad recording, please let them know it's being recorded. It will be uploaded to the YouTube channel and it can be watched. It just will not generate any credits for anyone watching it. And finally, last but not least, as you probably already know, we have a survey that pops up once this class is done. And it will ask you questions about what you thought of it, what you thought of me, what you thought of the materials, and let you add some comments. We always appreciate any feedback you have. I don't really think of it as good or bad feedback. It's just feedback, and it helps us improve. So don't hold back. Tell us what you really think, and we will use that to help improve our future programming. Okay, are we ready? All right. So let's start at the kind of the 10,000 foot view, as I like to call it. Why even have parking regulations? They're kind of a pain in the butt, aren't they? So why have them? Why do our associations adopt various parking regulations? Well, there's a whole slew of reasons. I just have a few up here, and I'm sure you guys have a whole bunch of other ones that you are thinking of as well, but sometimes we just don't have enough parking and we need to control who parks where and how much space we leave for guest parking and how much is just for, you know, residents being able to park. Sometimes our declarations contain restrictions, and whether we like them or not, we have to enforce them unless we amend. We have safety concerns that sometimes promulgate rules as a result. Traffic issues. Sometimes I've seen a community where they were like abutting another, like there were two condominium communities and the people from one condominium were parking in the other condominium, and so they had to enact some rules there as well. And like I said, there's probably a whole slew of other things that you could think of. And so then the question becomes, well, what kind of parking regulations do associations adopt? And I said, you guys see more of these than I do probably, but sometimes it's just flat out prohibited. Parking on the private street is prohibited. Sometimes we require vehicles be registered and have some sort of a tag being displayed so we know they belong in this community. A lot of times you assign parking, right? People have their assigned parking spots. Sometimes you only allow parking, for example, in the private streets between the hours of 8 a.m. and 5 p.m. Sometimes we only allow parking for a limited amount of time. So like for 2 hours to load and unload an RV, for example, right? We also have regulations on the types of vehicles that may be parked in a community, the size of the vehicles that may be parked in the community. There's all sorts of rules. And I think you all know that. Before I kind of go on, I think it's important to note that, you know, when you are adopting any kind of rules pertaining to parking, vehicles, that sort of a thing, I always recommend you let your legal counsel review those. I have oftentimes found that associations adopt rules that either, you know, conflict with their declaration or that conflict with Colorado law, because we have so many things now that associations can't control or can't really prohibit. So it's really important, I think, especially for the vehicle stuff, that you have enforceable rules in place and that you have legal, at least review that before you formalize it and start enforcing it. And speaking of enforcement, let's talk about that. How do we enforce these types of various parking restrictions when people violate them? So, you know, we got a lot of different things here. We got fines, towing, immobilization, other ones. Sometimes our declarations allow us to not let people vote while they're in violation, or 60 days after a violation. Sometimes we can take away their right to use amenities. That is all going to be dependent on what you have in your current governing documents, because things like voting and using the common elements, you would have to have permission in your documents to restrict that when someone's in violation. You can't just do it, okay? So if you are doing it, make sure you have authority to do that. But, you know, obviously one option is imposing fines, going through your enforcement policy, because that's how we enforce our covenants. We always, not always, but we have the towing option, immobilization, which is what your boots, when you boot a vehicle. And like I said, there may be other remedies available to you depending on what you have in your governing documents. So let's go through each one of these and talk about them. So fines. Yes, you got to go through the enforcement policy, because remember, in Colorado, we do not enforce fines until we provide notice and hearing to the violator. And if we don't do that, we cannot impose any fines. And the problem with this is, with these types of violations, we typically never get to the fining stage. Ever since HB 1137, you guys remember when we had to rewrite all our enforcement policies? The way that we can enforce has changed. There are now some mandatory provisions that basically say, you know, after you send the first letter, if they cure the violation, the next time they violate, you got to start all over again from scratch. So let's do an example here. You know, if Bob is parking on the street unlawfully and we send him an enforcement notice, typically the first one is like a courtesy notice. You send him the courtesy notice, Bob moves the vehicle. Great, he's complied. Tomorrow he parks it again in the same place improperly, and now you can't go on to the next phase of enforcement because he already cured the last violation. So this is considered a brand new violation now under the law, and you've got to start all over again with a courtesy notice. So the problem here is, with these types of violations, is we will not get to the fine stage because they're going to cure before we get there. And you are definitely not going to get to the part where you can turn it over to legal to initiate action against the violator. We used to be able to do that. We used to be able to treat repeat offenders differently and kind of escalate the process and not have to start all over again every time, but we can't do it anymore. And so unfortunately, every time that vehicle moves, the violation is cured. So that's the problem we have with following the enforcement policy. And ultimately, we really never get to the point we need to get to, which is having them comply. So for this reason, this is probably not the best way to enforce your parking restrictions. So, towing. Let's talk about towing, because this is really what I think the main focus of this class is going to be. So towing is a separate remedy. It does not require us to go through the enforcement process. It does require us, though, to follow current law with respect to towing. And if you've been following the legislation, we've had quite a bit of changes in the law when it comes to towing. And there are a lot of really weird and bizarre little requirements now. And we'll talk about those as we go. But before we do, the first question you really need to ask yourself before you start towing is, do we even have authority to tow? Does this community have the right to tow vehicles? Ideally, what we want to see is something in the declaration that specifically says non-compliant vehicles may be removed from the property. It doesn't have to use the word towing, but we want some sort of reference to removal. And if we don't see that, just know there's going to be a risk in trying to tow a vehicle. Ultimately, we always say, where does an association's authority come from? It comes from only one of two places. It comes from the law and it comes from its documents. That's it. So if you don't have authority in either place to do something, you don't ultimately have that authority. So in Colorado, there is no law that automatically says associations can tow from common areas for improperly parked vehicles. So that authority really needs to be in your covenants or perhaps your other governing documents, although ideally we really want to see it in the declaration. Now, so if we don't have it in the declaration, what then? Does that mean you can't tow? Well, not necessarily. I think part of it is we're torn here because on the one hand, if it's common area in a planned development, so like townhomes, single family homes, things like that, where the homeowners own their property and the association actually owns the common area, arguably one would think that if we own the property, we have the right to tow from our property. That is certainly the argument that we would set forth. But, you know, a homeowner could always come back and say, no, you had no authority to tow because you don't have that authority in law and you don't have that authority in your governing documents, therefore you do not have it. How would a judge rule? We don't really know because, you know, typically we don't see these types of defenses come before the courts, but given the recent tendency of judges to rule against associations, if at all possible, I think we need to err on the side of caution. My personal recommendation would be if you don't have specific authority, I would probably want you to do a limited amendment to the declaration. And yes, it's a pain in the butt to do that, but I would recommend doing one to add that authority in there. But before you even go down that road, have your attorneys look through the governing documents. If you can't find a reference to towing, let your attorneys look. Sometimes it's hidden in there. Sometimes there's some very broad general language that we can rely upon that allows us to tow. And other times, you know, it might be worth taking the risk and trying to tow without specific authorization in your governing documents, depending what your issues are. So before doing anything, remember, you got to make sure you have authority to tow. And I would check with your legal counsel on that one, because like I said, it could be hidden, or there could be some nuances that you don't pick up on that your attorney might. So assuming you do have the right to tow, the next question is, are you doing this in compliance with all the legal requirements? Well, you might be saying, Lena, what are the legal requirements? Aha, that's what we're about to go into, the legal requirements, because there is a whole slew of them. So the pertinent law, I gave you the statute citation. Most people don't care about the statutory citation. It's there if anybody really wants to read it. But one thing to note is this is not part of Kiowa. This is its own separate section statute. It has nothing to do with Kiowa. However, it does mention towing from private property in there, and specifically common interest communities. So it does apply. Now, this towing statute is really targeting the towing companies. It's not an HOA statute, it's a towing regulation statute. And basically, it talks about all the various things that towing companies have to make sure are done, and that if they don't make sure, they have the liability exposure. So arguably, we would hope that whatever towing company an association is working with, that towing company would assist the association in making sure it complies with all the requirements for towing from private property. And usually they do. I just can't speak for every single towing company out there. So who knows? Who knows? But we're going to go through all these weird requirements, and some make sense, some are just crazy. And then we'll talk about where you should be asking your towing companies to assist you. All right. So the statute basically says, this is towing company. When it comes to towing from private property, you can tow when you receive documented permission from the association, well, from the private property owner, which in our case would be the association, and that shows the following. So key here is, this is not auto-generated. It's not like something that just prints out when you push a button. It actually has to be in writing. It has to be signed, and some towing companies have different, things they want to see, but ultimately, they're going to want you to give them all this information. So what's the information? What you want to confirm that appropriate notice was given to the vehicle owner. We'll talk about what that means in a minute. You need to use a very specific form of notice that's created by the Public Utilities Commission. Now, those types of things, typically your towing company would give you. They have these forms, and they should be giving them to you. Otherwise, you can look them up. Otherwise, I know when we draft towing policies for communities, we typically attach a copy of one. So it's easy to get. Okay. The other thing that this permission has to say is that whoever's signing it is not earning any income from the tow, and that this person does not have any financial interest in the towing company. So basically, they want the law, the legislators wanted to make sure that we're not just towing so that somebody can make some money on the side. Again, kind of, never mind. I won't even go there. But anyway, that is what we need to show when we give the towing company permission to tow a vehicle. Okay. So let's talk about this notice. We said we gave the homeowner notice. So this is the requirements. It has to be in writing. It has to be on the windshield. I have had boards and community managers email and say, hey, is it okay if we put it on their passenger side window or on their driver's side window? The answer is no, it has to be on the windshield. There's like no way around it. This is what the statute says, on the windshield. And although it might be a technicality, this is exactly what's going to get towing companies and associations in trouble if you're putting it in the wrong place. This is a very specific requirement. Additionally, you have to provide at least 24 hours notice. Keep in mind, if you have governing documents that say you got to give them 72 hours notice, then you got to give them 72 hours notice. 24 hours is the minimum. So for example, if you have a declaration that says you only need to give 10 hours notice, that's not going to fly. It's going to be 24 hours. But if you have something longer than 24 in your documents, then yes, that you have to follow those. Okay. Now, what are we going to tell the violator in this notice? Well, we need to tell them that if the vehicle remains parked inappropriately, it is going to be towed. We have to tell them what they're doing wrong. You're parking in a no parking zone. You're parking, you've been here more than 2 hours and we only allow 2 hours of parking, that type, whatever the violation is. We have to tell them when their vehicle is going to get towed if it's not moved or the violation is corrected. So if you don't correct this violation, your vehicle will be towed tomorrow at noon. I mean, whatever the timing is. And finally, we need to have a phrase that says if you continue to park inappropriately, this may result in towing without further notice. Okay? So those are the things that the towing notice needs to have on it. Again, typically, I have seen towing companies providing the associations with the forms. So it's not something you need to create. And if you are getting these forms from your towing contractors, just take a quick peek and make sure it has that information in there. It should. Okay. But some of you are probably thinking, Alina, can't we just tow without notice, for certain things? And the answer is, yep, you can. Immediate towing. We got a few options here. Now, there's more than this in the statute, but the other options that I'm not talking about are options that don't really apply to us because they talk about if someone's repossessing a vehicle or you have a court order or something like that, which we wouldn't be doing. So I put the conditions up here that are applicable to us as HOAs, as private property owners. So this is what you would be looking for. 2 previous notices for the same violation. All right, so remember we were talking about Bob parking on the street when there's no parking, right? How would this play out? Bob parks on the street. We don't allow private street parking. We put a 24-hour notice on his windshield. We give him all that information. Basically say, hey, you're parked in a private street where there's no parking allowed. You need to move your vehicle or it's going to get towed tomorrow at noon. Bob moves his vehicle and cures the violation. Tomorrow he's back. He's back and he's parked on the street. Okay, so now we're going to give him another 24-hour notice, exactly the same as the first one, saying, hey, you're parked on the street. We don't allow parking on the street. You need to move your car. You could get towed immediately if you continue to park in this manner. Bob moves the car. Great. Next day, he parks it there again. So that's number 3. We've given him 2 violations. We've given him the 2 notices. Now you don't have to put anything on his windshield. Now you call the towing company, sign your form, and the towing company takes Bob's car away. Okay. That would be 3 strikes, you're out. So 3rd time they do it wrong, we get it towed. Keep in mind, though, this is if they're doing it wrong the same way, right? Same violation. If Bob, the 3rd time he doesn't park on the street, he parks in the parking lot, but he parks like over the parking line, takes up 2 parking spaces, that's a different violation. Now we got to give him another notice. So remember, it has to be 2 notices of the same violation. Next. And by the way, these are not ands, these are all ors. So any one of these would be sufficient for immediate towing. you have a vehicle blocking a roadway, a driveway, someone's access in and out of the community, someone's access to their garage, to their unit. If they're blocking access, that is grounds for immediate towing. So you could do that. If someone is parked, if we have handicapped parking spaces and someone's parked in a handicapped space and they don't have any tags, whether temporary or permanent, that is subject to immediate towing. Parking in fire lanes, subject to immediate towing. If you have assigned parking, in other words, people have their, each have their space assigned to them, and someone parks in someone else's spot, then that vehicle can be towed immediately. Now, with that type of thing, usually what ends up happening is the owner who has that spot assigned to him could call the towing company, or the association could, because I get that question a lot. Does it have to be the association? Can it be the owner? So in that case, it could be the owner. In most other cases, they're going to want the association to sign off. And then, of course, if you have permit parking or guest tags, they need something to show they belong in the community and they don't have any of that, absolutely, then you can go ahead and tow them immediately for that. So those are the situations where you could have immediate towing. And that's pretty much it for now. Okay. So kind of the next stage here is signage. There is a whole slew of requirements when it comes to signage. And by signage, I mean outside, in the parking area. And let's go through these, because if it wasn't so sad, it'd be kind of funny. So it has to be at least 2 square feet. All right. Your letters have to be at least 1 inch in height. And your letters have to, the colors have to contrast. Oh, I'm sorry, there's a typo. It should say contrast. Sharply in color with the background. I don't know what it means to sharply contrast versus just contrast with color. So your guess is as good as mine on that one. And the signage has to contain specific information. So it needs to talk about the restrictions on the parking, time when restrictions are applicable. If it's a 24/7 restriction, it has to say authorized parking only. Now, don't ask me all this. I am as confused by this as you are, because I'm thinking, so if we have a private street and we say no parking on the street, right? And it's a 24/7 application, no parking on the street, then we also need to say authorized parking only, which is weird because we don't allow parking. So why would it be authorized? But that's what the statute says. And then you need to have the name and the phone number of the towing carrier. Now, as an aside, the towing companies that associations hire typically provide the signage. So, and we want them to provide the signage, because then if there's something wrong, it's on them, it's not on the association. So if you're looking to contract with a towing company, make sure it's a company that will give you the appropriate signage and the appropriate notice forms, because you don't need to put the association in a situation where we screwed something up and we didn't comply with some little teeny thing like sharp contrast, So, so again, look for towing companies, and I think most of them do this, that are going to give you the signage. But there's more. We're not done yet. All right, there's still more for the signage. So it has to be printed in English and Spanish. It has to be permanently mounted at all entrances into the community, and it has to face outward towards the street so that it is visible when entering the property. Now, you also need signage inside the property that faces towards the parking area. You getting all this? goodness gracious. Now, what I would say is, you know, because people say, well, where do I need to put this signage? I mean, like, how many signs do I have to put? Where do I have to put it inside? And I think the general rule of thumb would be to err on the side of putting more signs up than less, right? So basically anywhere I park, I can see the sign somewhere telling me that I can't park here, or telling me that I can only park here for 2 hours, or however. So usually we're looking at like probably every few parking spaces. Towing companies, again, typically have specific, you know, thresholds they're going to use, and they will put those parking signs up for you. But just so you know, if you're looking around and you're in the parking area and you don't see, you can stand in a space where you can't see a sign anywhere, that it's going to be, when you tow from there, if you want to tow from there, it could be subject to challenge. So then the signs cannot be obstructed from view. Okay. And they cannot be higher than 10 feet off the ground or lower than 3 feet. You got all that? This is our signage. So again, rather than us having the association put itself at risk of not doing it correctly, which, as you can see, it's probably really easy to do it wrong with all these little things, please try to rely on your towing company. And if you are working with a towing company that says, oh, we won't give you signage, think twice about that company, because you're better off using a company that will give you the signage, because then the pressure's off the association, okay, and on to the towing company, which it should be, because the statute really is for the towing companies, not for associations. So wait, there is a little bit more. So the notice of parking rules have to be provided to drivers when they enter the property. What does that mean? Do you have any idea what that means? So here's some creative things I have seen associations do. Again, hopefully our towing company will tell us how they want to handle it, but sometimes the sign will have like a QR code on it. It'll say, scan for the parking rules. People can just scan it with their phone. I've seen if there's not a whole lot of parking rules, then sometimes they're just printed on the sign. But remember, it's got to be at least, 1-inch font, and it's got to be contrasting, and it's got to be in English and Spanish. So a lot of times there's just too much there to be able to put it all on the sign. I've seen like little, what do you call those? There's little boxes, like, when you see a house for sale, there's a little box where you can take out the flyer and look at the house. So I've seen associations post something similar with the rules in there, so you can pull over, grab the rules, and read through them. Now, who's really going to be doing that? I have no idea, but it is a requirement under the statute, and so you want to be careful. You want to make sure we are complying with this. And of course, their notice needs to say that you will be towed, you could be towed if you are not complying with the rules, and it's going to be at your own expense, vehicle owner. It's kind of like you have all these signs posted saying no parking, no parking, no parking, but you also need to make sure it says that vehicles will be towed at the owner's expense. So those are the requirements for the signage, the notices, all the fun stuff when it comes to towing. So just when you think we got it straight, I do have a few things I want to talk about that are of special note. First, public right-of-ways. I bet most of you know what I'm going to say. Public right-of-ways, we cannot regulate them, okay? Even if they're going through our community, they are not part of the community. They're public right-of-ways, and Kiowa was updated to specifically say associations cannot have any control or do anything with respect to how public right-of-ways are used. So what does that mean? It means we cannot prohibit parking we cannot have any parking restrictions as to how people park on these public streets. Okay. One thing that, you know, when this law was enacted into Kiowa, the not being able to control public right-of-ways, you know, public right-of-way is not necessarily just the street. Sometimes it's the sidewalk too. Sometimes it's the little green area between the curb and the sidewalk. So it can include different things. So you know, if you're not sure whether you have public right-of-ways or where the public right-of-way is in your community, I would recommend you have your attorney take a look. Usually we can figure it out by looking at the recorded maps and seeing what's been designated as a public right-of-way. We can also figure out usually how wide it is. It'll tell us in the map how wide it is. So basically, it'll like start at the center and say 25 feet each way. So if you really wanted to try and figure it out, you could stand in the middle of the street and count, you know, and measure 25 feet in one direction and see where it ends. That'll give you an approximate idea of where that right-of-way ends. Not that I expect any of you to stand in the middle of the street measuring it. Let's get that straight. I'm not recommending that. But anyway, if you're not sure if you have public right-of-ways or where they are, definitely make sure you have your attorneys take a look at it and tell you which streets, if any, are public, because those are the ones we can't touch. Any private roadways that are common areas owned by the association or common area, you know, in a condominium community, those are fine. Those we can regulate. Expired or missing tags. So the statute's pretty clear, and we cannot tow for this reason alone. So I have lots of phone calls from folks that say, oh, so we got this vehicle with expired tags, can we tow it? No, you cannot, unless there's some other violation that's going on. And then you would follow, you know, the appropriate processes we just talked about. But if there's no other violation other than they have an expired tag or they just don't have a tag, we cannot tow for that. Okay, so keep that in mind. That's gonna get us in trouble. But I guess now's the time to talk a little bit about, we hope that the towing companies we are using are actually knowledgeable in what the laws say. And even if we ask them to tow for an expired plate, they would not do it. One would hope. I never rely too heavily on people knowing the law or people doing, you know, advising correctly. So I wouldn't fully rely on the towing companies, but hopefully if we do make a mistake and we do ask a towing company to tow, they're going to catch it also. So it's kind of like a double checks and balances. All right. The next thing I would like to talk about is immobilization. So last year, or actually earlier this year, a law was passed. It's not in effect yet, but it talks about vehicle immobilization. In other words, booting or using any other type of immobilization device that we put on the vehicle to keep it from moving. I have heard, and so take this with a grain of salt, in talking with various booting companies, you know, their selling point is, you know what, if you tow, there's a higher risk there, because let's say it's grandma's car, grandma forgot her, you know, meds in the car and she needs them to stay alive and her car's towed. Uh-oh, right? As opposed to if you're booting, they can still get into the car and they can get what they need out and be okay. They just can't move. And of course, the flip side of booting is, well, yeah, but if we need the vehicle moved because they're taking up someone else's space, booting it doesn't help the other person, right? Towing is the only thing that's going to work. So, I mean, there's arguments for and against. But we do have the booting law, and it will take effect, I believe, January of next year. And it is very, very parallel to the towing. We just talked about all the towing, you know, requirements. So it's very, very parallel. There's a few minor differences, but kind of the biggest difference that I wanted to bring to your attention was that it only requires one notice before you you can't immediately immobilize. So, you know, we have to do 2 notices, and on the 3rd time we can tow. This is 1 notice, and on the 2nd time we immobilize. So it's a little bit of a quicker process, and I suspect that's because we're not towing the vehicle. The owner still has access to the vehicle, so we don't give them as many opportunities on that one. So one more thing I want to talk about is for those of you who are currently towing or want to start towing, I would very much recommend you adopt a towing policy as well that really spells out the process in conjunction with what we just talked about as to how, you know, we give notice, when we give notice, when we tow, because what that does is it puts the homeowners on notice of what the process is. They don't all know what the law says, but if we adopt a policy that talks about the process, then that is something that they will be aware of at that point. And what we've done, if you go through us and you have us ever prepare one of these, we have added the language with respect to immobilization. So now the policy will address both booting and towing. So it would basically spell everything out. And if you don't have a policy and you are booting or you are towing, be careful. I think it creates an opportunity for homeowners to question what the board is doing because they don't see anything in front of them, like anything in writing with respect to when we tow, how we tow. They have the signs, that's true, but as far as the actual towing process, they wouldn't know what that is. So just my 2 cents, think about adopting a towing policy that can be combined with parking rules, or it can be completely separate from your parking rules. It's totally up to you. Guess what? We have 18 minutes for questions, and there are a lot. Here, I'll let you look at this funny, very funny video. It's not a video, is it though? Okay. All right. So, there you go. Dancing chicken and pig. I'm going to start at the bottom. It looks like we do have quite a bit of questions. So I'm going to try and go through all of these if we can. First question, what do you do when the county sheriff's office won't enforce parking issues with RVs on streets? So again, if it's a public street, there's nothing you can do. I mean, there just isn't. Sheriffs will not, the police will not typically tow from private property, like I said, unless they're parked in someone's space or something like that. I mean, actually, no, the police wouldn't tow it. It would have to be a private towing company. The police isn't going to do anything on private property. So if you have a public street and you're asking the police to tow a vehicle that violates local ordinance and they're not doing it, you know what? There's really not a whole lot you can do. And that's unfortunate, but that is how it is right now. All right. Question regarding vehicles that are not parked in assigned spaces but have remained in the same location within the community for more than 30 days. The governing documents say no longer than 30 days. The vehicle in question are operable. Okay, so basically, can we proceed with towing vehicles that have been parked in the same space for more than 30 days? You would have to follow the policy. It says you would not be subject to immediate towing. It doesn't fall under any of the immediate towing options. And so you would have to go through, you have to make sure, obviously, you have the signage. You're going to have to make sure you have the notice, that you gave them a 24 hours notice or something longer if it's required under your documents. So you're just going to have to go through the policy and the process. Does the authority differ if it is an HOA street? Yes. So we just talked about whether it's a public street or an HOA street. So I will. What if the parking restrictions are in the rules and regulations, not in the declaration? So your parking restrictions can be in the rules, but there's a very fine line because they can't contradict anything that is in the declaration, and they can only kind of expand on what is in the declaration. So if the declaration says, you know, the board has the right to adopt rules governing the types of vehicles that may be parked in the community, great, we're going to adopt a rule governing the types of vehicles. If the declaration says no, no large vehicles, no commercial vehicles, we can have rules that clarify what those terms mean. What is a commercial vehicle? What is that? What, you know? So you could have rules to that extent. So I think it just depends on what you have in your rules and what you have in your covenants. Can management call in a tow on behalf of an owner that has an assigned or reserved parking space? Yeah, you can. You absolutely can, but the owner can do it as well. Sorry, I'm just trying to get to all the questions. For windshield notice, can it be a sticky notice? Yeah, usually it does have to be sticky because it has to stick to the window so it doesn't fly off when it gets windy. And I know a lot of associations use stuff that's extra sticky because it's very difficult to get off. And hopefully it helps those vehicle owners realize that they don't want to be parking improperly. So the driver's window isn't sufficient. It needs to be the windshield, correct. I was told if we put a sticker on a window that blocks their view, we carry liability for making it an unsafe vehicle to operate. You might. What I think most associations do is they put it on the windshield on the passenger side to kind of avoid that liability. So if that's a concern, definitely put it on the passenger side, on the left side. That's where I would put it. And that way you don't have to worry about them trying to drive off and hit another car because they can't see where they're going. So the driver's window, oh, sorry, it's the one I just read. If the towing company instructs us to place the sticker on the driver's door, but we push back to the towing company indicating that the sticker must be on the windshield per the law, and the towing company refuses to come on site to remove it until the notice is on the driver's side door, what direction should we take? Follow the towing company to get the vehicle removed, or inform the board that the towing company is providing incorrect instruction for towing and that you are unable to act? I think, well, I would probably look for a different towing company, for one. Two is if they give me something in writing that says you have to put it on the on the window instead of the windshield, if we get something in writing, then I think we can rely on that because they're the professionals. They're telling us that we can do this. So if a homeowner comes after us, we're just going to bring in the towing company saying this is what they told us to do, and we had no choice. They wouldn't tow it otherwise. If they won't give you anything in writing, I would be a little bit skeptical to tow, just because we don't want, the association getting in trouble for it. So I would be a little hesitant on that one if we can't get anything from them. What is the time frame for the two previous notices? Like they had one violation 4 months ago and the second 2 weeks ago. Can we still subject the vehicle to immediate towing? So that's a great question, and the statute doesn't really tell us that. So my recommendation is to be reasonable on that. So if it's been like a year since they did the same thing, I wouldn't count that as the second notice, right? I think a year is way too long. 6 months, maybe. I probably wouldn't, I'd probably say up to 6 months. I'd feel fairly comfortable allowing you to treat it as a second violation. Anything longer than that, I think is going to be questionable. So, can I tow if the HOA owns the road and an unregistered vehicle after 2 separate notices? No, because we can't tow for unregistered vehicles, unfortunately. If there's another violation that is occurring, and we've given them the 2 notices that way, then we can tow for the other violations. But if the only violation is the unregistered, we cannot tow for that. The statute's very clear. The immediate towing would not include things like not having proper registration. I have a board member on the call. They want to tow for not having valid registration. Right, same question, same answer there. Can we tow, can a vehicle be towed immediately if there is a rule about distance required parking from fire hydrants? No, unless it's a fire lane. Otherwise, no. Do we have to have the required signage to tow a vehicle for the reasons on slide 11 for immediate tows? Yeah, you need to have it no matter what. And if you don't, I would suspect the towing company will not tow it. At least they shouldn't tow it. But yeah, the signage is irrelevant to, whether it's immediate or not. For immediate towing, would this also take effect for registered, unregistered vehicles? So again, no. So that was the same question. All right. Typically, towing companies don't provide signs with the rules specific to each HOA. That's true. How can we have the separate sign reflecting the parking regulations separate from the towing company sign? Again, you could do that, or you could do one of the other methods that we talked about. Some associations get super creative. And then it says for the signage, does all the required info need to be on one sign? So it doesn't specifically say that in the statute. I think if we had 2 signs, I think that would be fine. But again, too much signs, you're not going to be able to read it all. So, again, you want to be somewhat reasonable. Would there be any reason why an association can't reduce the amount of handicap spaces as long as it meets the local requirement for minimum or ADA minimum? So if you already have handicap spaces in your community, you need to go through your local zoning department or your local through the county, because you need to get permission, is my understanding, to remove handicap parking spaces. So you would need to go through that process. So you wouldn't just be able to do it on a whim. You would have to ask for permission from the city or county. What do you recommend when towing companies are not following the signage requirements and do not have good communication or action when asked to put up compliance signs in the locations that are required? I would say probably time to look for another towing company, because there are going to be towing companies that don't take this seriously, and we don't want to get caught in the whirlwind of their liability exposure, because the association's going to get named. Whether or not we have liability is one question, but getting named, they're always going to name the association as well, and we don't want to have to deal with that. We don't want another claim on our insurance policy. So I would recommend that if you're having a contractor that's just not doing, and they're not doing it right, at least consult with another towing company and see what they say, because there are towing companies out there that do it correctly. Could or would signage that states parking without authorization /permit/tag immediate towing for the immediate towing slide take the place of the defined required signage slide details? Also, does authorization need to be defined? It's not going to take the place. You still have to have all that signage. This is not in lieu of, this is in addition to. And authorization, if you're using that language because of what the statute says, that's the language that's required. I don't know I don't know how we would define authorized vehicle if it's a no parking zone, to be honest with you. So that's a good question. What do you recommend when towing companies are not following sign? Okay, we already did that. Who pays the cost of booting? Still the owner of the vehicle? Yes. So what they do is, I read that when they put the boot on, that the person who wants to get it off, there's like a number they can call or somewhere where they can like actually pay to get the boot released. And then they leave it there and the company comes and picks it up. So it's almost maybe like a little credit card machine. Stick your credit card in to get the boot off. So that was, yeah. Can you tow if they are parked on HOA common spaces? So again, it would be subject to all the same stuff we talked about. And I mean, because we wouldn't really tow from property that isn't a common area. Like I would never recommend you tow from someone's driveway, because that's just a whirlwind of problems waiting to happen. So you usually are just going to be towing from the common areas. Can we tow for inoperable vehicles? Per our rules and regs, expired tags makes it inoperable. So again, you can't tow for expired tags. If you have they can't be inoperable, and inoperable is defined in a way that doesn't include expired tags, and they fit under that definition, then you would follow, you know, the towing policy and the steps we talked about today and tow it then. I have a homeowner that is running a used car business out of his house. The streets are public, but he rotates the cars through the pool parking lot, which is private with signs. They keep removing the tow stickers that I put on. They also move the car 1 or 2 spaces down, showing that it moved. What is the best approach to this? I think it depends as far as what the specific rule is. Like if it's that you can't park in the parking lot, in this parking area, no more than 2 hours consecutively, then once they moved it, they've cured it. And next time it's parked for more than 2 hours, you put a second notice on because it's the same type of violation. And then the third time it's parked there more than 2 hours, you would tow it. But I think it just depends on how the rules are written and what it is specifically that they're violating. Sorry, I think I already looked at this one. Okay, we're not going to get through all of these. I thought we would, but we're not. Are we able to outsource parking management to an outside company? Yeah, of course. You can definitely outsource. And like I said, just make sure when you're outsourcing, it's someone who actually knows the law and someone who's going to comply with it. Okay, this one we've already answered. Let's see. We are having problems with large conversion vans and work trucks parked in private areas. Is this enforceable, assuming it's spelled out in the rules? As long as the rules comply with what the declaration has. So if your declaration does not prohibit commercial vehicles, for example, you can't prohibit them from in the rules. They have to be prohibited in the declaration first. And we would define what that means. So you might be able to do it, but we would need to look at the declaration to make sure that rule is enforceable. What should we do? Last question. What should we do when we have called multiple towing companies and when we say HOA, they immediately deny services? How would I word this better to get their services if needed? So I know there are quite a few towing companies that do work with HOAs that have no problem working with HOAs. I couldn't tell you what they are. I think maybe Max Towing is one that I've heard before. But I'm not sure if you are a manager, your company might have some towing companies that it works with. If you are a board member, I would ask your community manager what towing companies they're aware of. So, but there are towing companies out there that for sure will work with HOAs. So I apologize, we're out of time, and for respect of everyone's time, I'm not going to go over. If you have questions that were not answered, my email's on here. Please feel free to reach out. I will do my best to respond as soon as I can. Sometimes it's going to take a few days, but I will try to get to your email and try to respond. Thank you so much for attending. I hope this was helpful, and please fill out the survey if you have time. Thanks, everyone.